Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing Thai tourist visas, U.S. tourist visas, and a previously filed K-1. I occasionally get this question, and I was hesitant to do a video on this because this kind of thing is very, very fact dependent. So I'm going to talk about this generally, but if you are looking to do this, you probably want to contact a legal professional and get some insight and guidance on this because there's a lot going on here. So a K-1 visa is what I call a sort of dual intent visa. It's technically a non-immigrant visa insofar as it allows the applicant to apply for 90 days as a fiance of an American citizen to travel to the United States specifically for the purpose of getting married within 90 days of arrival and thereby applying for a green card thereafter. Now, if you don't actually do that and you leave within 90 days, it's a non-immigrant visa, no harm, no foul. The dual intent aspect of the K-1 is the fact one can get married and then file for what's called adjustment of status in order to gain lawful permanent residence in the United States, a green card. And that's kind of where the immigrant intent aspect comes from. So K-1s are treated for processing purposes like immigrant visas. So it processes through the immigrant visa unit at the U.S. Embassy here in Thailand when we deal with them here in Thailand. And for this reason, again, they're technically non-immigrant, but they have a dual intent aspect, so they're immigrant for all intents and purposes. Now the question here is, can I apply for a tourist visa after I've applied for one of these? I get this question a lot, especially right now with all of this COVID backlog. People want to be with their loved one. They want to be with their fiance. The problem can be, and again, this is all going to be very fact dependent. It's going to depend on the specific facts in one's given case. But the problem here can be that the intent of these two types of travel documents are not in sync. A tourist visa, one specifically has to have non-immigrant intent, and that has to be adjudicated pursuant to what's called Section 214B of the Immigration and Nationality Act, wherein the adjudicator, the consular officer, must determine that the applicant has strong ties to their home country and this is key, weak ties to the United States. Having a K-1 on file can create something of a conflict with that adjudication. Now, again, facts are going to, drive the analysis on that. There could be a set of circumstances I can see out there where someone might legitimately need a tourist visa, notwithstanding the fact they're waiting around for their K-1 visa. And as long as they were to come back from their tourist visa and process their K-1 as per the regulations, that might not be an issue. But again, you need to be careful with this, and more than anything, to make sure you don't throw away good money for no good reason. But probably a good idea to contact a legal professional, gain some insight and guidance into how best to proceed.